All right, so good morning, everyone. We're going to go ahead and get started so that we can be respectful of everybody's time this morning. I know that everyone's busy. But look, I just wanted to welcome everyone and say thank you for being here. We are so excited to see everybody in person again. You know, it's been so long since we've had a chance to do one of these breakfasts with our friends and our clients and see everyone in person. So thank you so much for being here. For those of you who don't know me, my name is McChristian, and I'm one of the partners in the construction group at Hedges. And this morning we're going to have a panel discussion where we're going to talk about price volatility and supply chain issues and how you can manage the risks associated with those issues in a construction contract. Now, this morning, as I said, is going to be a panel discussion. It's not going to be one of those presentations where you've got one person standing up in front of a PowerPoint presentation. And we did that intentionally, right? Because we want this to be a conversation. So it's going to be a conversation between the three of us up here. And we want it to be a conversation with you as well. So if you have any comments or questions or if you would like to add to any of the discussion, please feel free to do so. Because we want this to be as interactive as we can make it. So like I said, I'm McChristian, and you see that there are two other people that are up here with me. So the first person that we have is Amy Wolfshohl. Amy is also a partner in the construction group at Hedges. Amy is, in my opinion, one of the stars of construction law in the state of Texas. She is certified by the Texas Board of Legal Specialization in Construction Law. She's been recognized by Chambers USA, the Legal 500, the best lawyers in America, super lawyers, pretty much anyone you can think of has said that they have a similar opinion of Amy as I do. Amy does both construction litigation and she also does a lot of contract work. So she's kind of in the trenches dealing with these issues on a daily basis. Now, the other person that we have up here is Jack Byrom. Jack Byrom is one of the rising stars in construction law in the state of Texas. He's one of the senior associates in our construction group. And Jack has a similar practice, right? So he both litigates and negotiates contracts. And Jack and I actually work together quite a bit on negotiating contracts in the industrial sphere where we also deal with these issues regularly. Okay, so to jump into our discussion, I kind of want to set the stage first. I think everyone who has any association with construction knows that the supply chain issues that really started in 2020 during the pandemic have not gotten any better for the most part as the pandemic has receded. It just seems like, every time you turn on the news, there's another issue that is compounding these issues and seems to continue to be extending these issues. And so I don't think this is going away anytime soon. But just generally, kind of in setting the stage, Jack, what are some of the different types of project delivery systems and pricing structures that you can have in construction contracts where price escalation issues can come into play?
Well, I think that most of us that work in construction are familiar with four main types of pricing structures. The first one, which sort of speaks for itself, is lump sum, a set not to exceed price. You also can agree to price contracts on a unit rate basis where the parties agree on what what rates will be for individual types of labor, for equipment, for materials, but that the quantity is not firmly established. You also have cost plus, which is going to be purely a function of what the contractor's cost is plus an agreed markup. And also time and materials, which is fairly similar. It's based on the actual work performed, the cost of that work, and passed up to the general contractor or to the owner, depending on what your relationship is in that organization. But those are the four main pricing structures that I think most construction workers deal with, and the ones that we're going to be talking mostly about today.
Okay, and Amy, so Jack just laid out kind of four different pricing structures. Can you have different types of pricing structures in the same agreement?
I see a lot of different contracts with multiple pricing structures, and I think that's one of the ways that parties in the construction industry are dealing with volatility you can mix and match lump sum and T&M to account for some of this volatility in particular materials, right? With both T&M structures and cost plus, basically what you're looking at primarily when it comes to materials is the cost of materials plus a markup. One thing I'll caution everybody to do is to really look at the contract and determine whether the contract actually deals with these other types of pricing structures. When I get involved in the back end on a lot of these things in litigation, what I note is that when parties have tried to allocate different pieces and parts with different pricing structures, they've really just developed a contract that only deals with lump sum. That's kind of the general basic pricing structure. And so if you're going to use mix and match pricing structures, spell that out in the contract. What portion's lump sum, what portion is T&M or cost plus, because otherwise on the back end, people are going to make arguments that maybe weren't intended, right? But you can use these different pricing structures. You can mix and match. It just comes with an asterisk. Make sure you know what you're doing up front.
And so, Amy, when you have these different pricing structures in the contract, do the different pricing structures that you can use, do they affect the risk profile for either owners or contractors when it comes to material supply issues and delays?
I think they definitely do, and let's just assume right now that prices are continuing to increase. Okay, let's make that assumption for the purpose of my answer, although we all know that some of the pricing of materials is going down, and so that's why I say let's assume they're going up. Generally, if you're looking at a risk continuum from an owner's perspective, lump sum is going to be the least risky. Then I would say unit price, which can be fairly similar to lump sum. Then I would say cost comes next, and then T&M. Okay, and the reason for that is there's no cap on T&M and cost contracts unless you place one, right? And so generally, when prices are rising and we have a volatile market, the owner's side tends to prefer that you have lump sum because your risk is less. One of the things I think about is if the contractor can't tell you how much a project's going to cost, how is the owner supposed to determine how much it's going to cost? And I have been involved in litigation on T&M where the project ended up costing double what was originally anticipated. And I think just the reverse is true for the contractor, right? When you're looking at the risk profile from the contractor perspective, contractors take a lot less risk when all their costs are going to be reimbursed. But with that comes some drawbacks, right? You might be subject to audit provisions and other provisions in the agreement that are going to open up your books. And so you just have to be careful what you wish for. But generally, I think that's how the risk gets allocated.
Okay, great. Okay, so as we're talking about these issues, I think just overall, there's really kind of there are different contractual provisions that can be included in a contract that can impact a price escalation issue or be used to mitigate the risk of price escalation going forward. And the way that we're going to talk about these different clauses this morning is first we're going to talk about an actual price escalation clause, right? So one of the things that is becoming more and more common in construction agreements is we're seeing actual clauses that talk about what happens when the price changes for certain defined materials, or if there are changes in the price of equipment or something along those lines that's being provided under the agreement. So first we're going to talk about actual price escalation clauses. And some of the issues that we see when we are negotiating these, and some of the issues that we try and keep top of mind whenever we're reading one of these to see if we need to make changes to it. And then so after we talk about price escalation clauses themselves, we're going to talk about some of the other provisions that we typically see as impacting a claim or impacting the risk that's associated with market volatility. So first, I mentioned price escalation clauses and said that's what we're going to start with. But Amy, just kind of set the stage for us. What is a price escalation clause?
A price escalation clause really needs to account for both upward and downward pressure in price. Okay, so what we do is we have a a group of materials that we've decided at the outset, really, we don't know what the price is doing with this particular material. And so how do we account for it both from the outset and going forward to basically take the risk from either party's end and just know once that material is going to get ordered, once it's going to get supplied, how are we going to set the contract price? I say generally that's what a price escalation clause is, but it should account for both upward and downward movement.
Okay. And so from an owner's perspective, Amy, what are some of the benefits to including a price escalation clause in your construction contracts?
Well, I think with the volatility that we're seeing, if some owners aren't accounting for some of this price volatility, you might reduce the number of bidders that are interested in the project to start with, right? So some contractors don't have a risk profile to take on these risks. And so you're increasing the number of bidders. Additionally, we're seeing lumber go way down right now, right? And so, if you don't account for the downward price pressure as well, then you might end up actually overpaying, right? And when contractors take on risk, they can, of course, build more profit overhead into the number. And so there's definite benefits from the owner perspective as well when determining whether or not to put a price escalation clause in the contract to begin with.
Sure. And, I think one of the things that's important for owners to consider is also what is the pool of bidders that you're going to get for any particular project, right? And so, kind of one of the things that I see as being a benefit for an owner to including a price escalation clause in their contracts is you can potentially expand your pool of bidders, right? Because there are certain contractors that are more risk adverse than others. And so, because of that their risk adverse nature, they may avoid bidding certain projects, right? If they perceive that there's too much market volatility, or they believe that the owner's not going to work with them on reasonably responding to those types of price fluctuations. And so in my view, I think an owner can actually expand the pool of bidders that they may have on any particular project if they're open about being willing to work with contractors in resolving these types of issues.
Well, and I think that those are really important to consider, because I think when people think about price escalation clauses, they're usually thinking about it from the perspective of the contractor being protected and the benefit that it affords to the contractor. And I think thinking about why it's actually beneficial to the owner for all the reasons that Amy and Sean said that really gives the owner more incentive to consider this. Whereas I think what I hear from a lot of when I'm representing contractors and negotiating these agreements, a lot of owners are not interested in anything that changes the price of the materials at all. And so I think it's an interesting thing to consider that it may actually be to the owner's benefit.
Now, there are, of course, there could potentially be negatives or drawbacks associated with including a price escalation clause in your contract. And Amy, from an owner's perspective, what are some of those drawbacks that an owner may perceive or actually suffer?
Well, I think, again, sort of the baseline rule is that owners generally want lump sum agreements. They're used to the contractor taking on the risk of material volatility and labor volatility and things like that. And so I think that you can take on a risk that you're not ordinarily used to taking on, and there's different ways to manage it. It's going to create more paperwork to try to manage the price increase, which we're going to go into a little bit more. So I think it's generally just taking on a risk they're not used to taking on. That would be probably the primary downside.
Sure. And Jack, so from a contractor's perspective, what are some of the reasons why a contractor would want to have a price escalation clause in their agreement?
Well, I think the obvious one is the contractor feels that they're protected if the market increases beyond a certain amount to where it becomes untenable for them to do the project at the price they originally bid. And it's more, a price escalation clause is specific and addresses the situation in a way that other contractual clauses that you normally shift risk, such as force majeure, change order provisions, may not address. And we're going to talk about those a little bit later. But I think it provides the contractor with more certainty, which, as a benefit, reduces the risk profile that the contractor takes on. Now, the drawback to that, of course, is that with lower risk comes lower profit. And so the trade-off there is that the contractor may have more certainty in what their exposure is, but they will almost certainly have a lower chance of a high profit on the project when it's completed.
I think that's absolutely right, Jack. And I think one of the other things that that contractors also kind of view as a drawback associated with these clauses is and we'll talk about this in connection with best practices and how to negotiate these. But often, in order to have a price escalation clause, you have to set a baseline, right? You need to know, okay, here's what the market is doing right now, or here's what our pricing is right now. Because if the owner doesn't know what the baseline price is or the baseline cost of equipment or materials are, how can you then later know whether or not that price has changed, right? And so on lump sum projects and really on other projects, contractors may be hesitant to provide that information to the owner, right? Because they've got to provide an increased level of detail into their pricing that sometimes they aren't normally used to doing. So that can be considered a drawback. But I think it's one of those things that if you're a contractor, you just got to accept. We're going to have to provide this information if we want to potentially be protected if there's significant changes in a certain material or certain equipment that we're going to be provided. Now,
and I'm sorry to cut you off, Sean. The one thing that kind of leads to contractors obviously really don't like and try to fight against onerous audit provisions of their contracts and of their costs. And it's going to be really hard for the contractor to justify a narrower audit provision when there's an escalation clause that essentially may turn the contract partially into a cost plus agreement. And so the contractor is really going to have to, as Amy said, open up the books and prove not only that there was an increase in the market, but also an increase to the actual cost. And that of course depends on how the price is adjusted, which we'll talk about when we sort of move into drafting the actual clause itself.
Sure. And so one of the things that we put on the table in front of you is we provided you with an example price escalation clause. And so what you've got is a copy of the consensus docs suggested price escalation clause for use with their contracts. It's hard to say that any price escalation clause is perfect. I think there's always going to be tweaks that can be made to each clause, but I think that this is a good baseline for us to start our discussion around and kind of look at the way that consensus docs deals with these types of issues. So when we're talking about best practices for drafting a price escalation clause, what are, Jack, just kind of up front, what is one of the first things that should be done in every price escalation clause when you are negotiating it or drafting it, or what are some of the first things that you should be looking for?
I think the first thing that you have to do is identify what materials you're talking about. That you cannot have a price escalation clause, in my opinion, that applies to all materials on the contract, because it's going to become so unwieldy, and you need to identify with specificity the materials that you are going to negotiate these adjustments for. And so that's something that, whether it's, lumber, whether it's steel, concrete, anything, I've even seen some escalation in foam and concrete foam. Those are all things that if you think as a contractor or an owner that are subject to significant volatility, you need to specifically call those out in the agreement. And one of the things that the consensus docs agreement does is it has a Schedule A, which attaches a list that you can then put in and use that as your list of materials that's going to be increased or subject to increase and decrease. The other thing that I think is critical is defining what triggers an escalation of the price in the parties' agreement. You're not going to want to adjust the price of materials for every up and down fluctuation by dollars and cents. One of the things that frequently is done is there is a trigger mechanism that's usually defined as a percentage increase or decrease over the baseline cost that the parties agree to up front. And I've seen things from anywhere between 10 and 20% of an increase, usually something closer to 20%, where once you exceed that amount of fluctuation, the price escalation clause gets triggered. And that's something that you're going to want to know ahead of time. You're also going to want to know, how are we measuring that percentage increase? Is it going to be based off of the contractor's actual cost, Or is it going to be tied more toward an industry-wide index? Or is there going to be some support for both measures to be used? The contractor obviously is in sole control usually of their relationship with their vendors and their suppliers. There may be times where the contractor can get a really good deal relative to everyone else. There may be times where they can get a really bad one. And so if you're only relying upon the contractor's cost, you may take on the risk as the owner of dealing with the contractor's economies of scale and being subject to that. And so there are price indexes from the Bureau of Labor and Statistics. There's the construction cost index from Engineering News Record. There are others in the industry that can be used to measure when costs have increased beyond what is sort of the baseline the parties have agreed to in their agreement. So those are, I think, the most important ones, but you also have some other considerations you want in as well. For instance, does the contractor, when they're charging a markup on their materials, do they get the same markup on those materials if the escalation clause is triggered? Potentially you're going to be, if there's a percentage-based markup, there's going to be higher and higher and higher profits well beyond what the contractor and the owner envisioned at the time the parties signed their agreement. And so the owner wants to consider if they want to try to limit that. I think from the owner perspective, they're going to want procedural requirements to be in place for these provisions. Written notice from the contractor, timely written notice from the contractor. There should be an opportunity from the owner's perspective to consider alternative materials, alternative suppliers. If they want to make a joint decision to do that, there should be a provision in there that allows the owner and the contractor to do that. And I think that the other thing we've all talked about is this baseline cost increase, but do the parties want to, on the front end, and I think the answer is usually yes, agree on what that baseline price is. And so, we have the Schedule A that lists the materials that are going to be subject to an increase. Well, what are those actual prices? Because if you don't have that in the contract, then are you just comparing industry indices to each other? Are you comparing costs to each other? I think you need to establish some kind of baseline, or there's going to be too much uncertainty and too much chance for litigation. And also consider on this back end, like Amy's mentioned, whether the decreases in the price will trigger an escalation that results in a downward adjustment. And I think that usually when those types of agreements are put in place, it makes the owner more likely to accept those kinds of provisions because it allows for the parties to feel like they're both sharing in the risk. So those, I think, you identify the materials, you have strict definitions as to what causes what triggers the clause, price increases, decreases, and then you have to account for what is actually going to happen when there is an escalation and how that's accounted for on the project. So those are the kind of the ways I would group all of those things into three sort of phases, but those are the most critical issues for these clauses.
Sure, and so if we look at the example clause from the consensus docs, I want to kind of walk through these provisions and talk about some of the ways that the consensus docs deals with the kind of best practices and the issues that Jack just discussed. So in paragraph 1, which is labeled potentially time and price impacted material, how does the consensus doc provision deal with some of these issues, Amy?
And I'll just start by saying I think the consensus doc does a pretty good job of addressing all the issues that Jack just laid out. It's a fairly balanced way to deal with price escalation and price decreases. One of the things the introductory clause does, though, is it loops in delay into this as well, which I think makes the provision a little too complicated, honestly. And that's probably the main change I would make to this if I was going to redraft it. It deals with both, we're going to talk about increase in price and, and by the way, we're going to allocate delay here as well. I put delay in a change order clause, and I have, force majeure is looped into it, and I have very specific ways that, delay has to be addressed, and including through demonstrating critical path. And so I think that it deals with delay in too summary of a fashion, but other than that, I think it's quite a nice clause. And so, paragraph 1, we get into, essentially what this clause is going to do. Paragraph 2, and I'm just going to jump ahead of you, Sean.
You're good.
In paragraph 2, it makes clear that it's only for identified materials that are going to be in the addendum, right? I think that's core to any of these clauses, is identifying what actually does this pertain to. Then the clause mentions, and I think this is great too, if you're allocating for price increases through a material escalation clause, you're not also going to have a contingency, right? One of the things we really haven't talked about yet is sometimes there's just a contingency for materials that we don't really know how much they're going to cost. And that's another way to deal with material price increases that doesn't involve kind of a complicated clause, really, is how I would describe this. And so if you're going to have a contingency for materials, you don't also have the same materials dealt with through this type of a clause. You know, in paragraph 3, what is good about this clause is, you know, it very clearly mentions we're going to account for increases and decreases in price, right? And it makes clear that that the price impact of material is not going to include any amount for overhead and profit. So this is similar to what Jack was talking about earlier. You know, if a material goes through the roof and you have a clause to account for that risk, then, you know, it's not really appropriate to add profit and overhead on that, just like any other change order, right? Because you're accounting for the risk through the clause, and so you shouldn't add that on top of it. I'm sure there's plenty of arguments on the other side, but at least the consensus documents felt that this was a middle position, and I tend to agree that is the middle position. Then we'll note in 3.1 and 3.2, the adjustment is only effective after notice. And I think that's a great way to deal with this. So we're not going to have a situation, if you use this clause, or at least we shouldn't, where you get to the end of the project and, oh, by the way, the lumber costs twice what I thought it was going to. The increase in price that you get is only going to be effective after notice. The same thing is with the decrease in price, right? So that means that there needs to be continual monitoring with the baseline versus the increase. I think that's a great way to deal with it. You know, we're not going to have this adjustment effective unless you give the notice.
Well, and I think what's interesting here, Amy, is from the contractor's perspective, this is a written notice provision that's actually more lenient than most that I see. And the reason for that is because there's not a strict timing requirement, and there's not language, although the adjustment does not become effective until written notice is received. There's not a total waiver of all future claims for an escalation if you don't notify with written notice in a timely way. So when coming back to you talking about how it's a more balanced provision, this is one of the ways in which I think that I agree, and that's one of the ways in which it is.
And then, you know, in 3.3, it makes clear there could be a limit to the adjustment, right? And so the parties can agree from the outset that we're not going to go above a certain percentage, above a certain amount for any one of these materials. You know, that puts a cap on risk, such that, you know, the risk will transfer back. And so, you know, whether or not you want to include that, I think it depends upon what the deal is, what the volatility is, but that is part of this form agreement. And then finally with 4, that's getting back to the delay issue, which I really recommend goes in a different clause. And so if you were to use this form, if you were to use this, I think you really have to, from the outset, decide, do you want to deal with both delay and your pricing impacts in the same clause? And I really kind of suggest that you don't. But then when we get to the Schedule A for this amendment, it gives a variety of ways that you can set the baseline. It gives a variety of suggestions, and I think, you know, depending on your project, many of these different baselines could work. If you read the second sentence, it says the methods for establishing baseline price for a potentially time and price impacted material should be based on an objective standard. I'd agree with that. And it can include established market or catalog prices, actual material cost indices, or another mutually agreed method, right? And I guess kind of the most interesting one of these is, how do you set that actual material cost, right? Is it through a single invoice that the contractor demonstrates as a material cost? Is it a bid process? if I was looking for an improvement to this clause, I would probably want to have multiple supplier invoices if I'm going to use the actual cost of material. And I definitely wouldn't just want to rely on a bid for that. So if you're going to go through the trouble of negotiating a clause that's this specific and this detailed, I think that's a point that could be improved in the form. But I think, overall, I think this is a nice start to, really thinking about how you're going to deal with price escalation clauses in a construction contract.
Yeah, absolutely. Now, so we talked about a price escalation clause and some of the benefits to actually including one of these clauses in your agreement. But, like I said before we started talking about these clauses, there's a whole host of other provisions that you'll find in a construction contract, or really even ways that the contract can be set up from the outset that can either impact one of these claims or can affect the way that you approach this from a contractual perspective. So one of the first things that I want to talk about, Amy, is the situation where the owner takes on the obligation to supply certain materials to the contractor instead of it being 100% contractor supply of all materials and equipment. Now, in those types of situations, Amy, does the owner take on additional risk when it's supplying key materials?
Sure. I see, owners supplying equipment, materials a lot in large industrial and energy-based projects because they really have to kind of start way before the contractor's on site in procuring those materials. And with that comes some additional risk, right? You're no longer really worried about price escalation from the contractor perspective. The owner has taken on that risk. And also, you have to account for the risk of delays potentially in the project when the owner takes on that risk. I think a lot of times owners are in a situation where they really can't avoid taking on that risk, especially for these large industrial and energy projects, because you just have to start, from the get-go. And the way that owners can account for that risk would be through a very well-drafted delay clause is probably what I would say. Because, when you're talking about when the materials get delivered, when the equipment's going to be delivered to the project, the main risk there is that, you're going to have an impact from the contractor if you have a delay. And so, how do we account for that delay? And we're going to talk a little bit more about that when we get into our change order discussion.
Sure. And Jack, so just kind of from a high level, if the contractor is responsible for supplying the materials on a project and you don't have a price escalation clause, what are some of the other provisions that you can look to that can potentially impact those claims, or something that the contractor should consider in evaluating how to structure their presentation of this type of claim to the owner?
Well, when I was thinking about this part of the discussion, I was reminded of one of the first cases that I ever worked on, which involved a vessel construction agreement where the contractor was trying to procure engines from Scandinavia, and they were delayed by about 9 to 10 months. And there was also a significant price increase because the price was based off of the Norwegian kroner. And so there is, and the exchange rate fluctuated wildly. So we had not only a major delay issue, we had a major cost increase issue. And the main arguments in a proceeding like that, if you go to litigation, are going to be over the application of the party's force majeure provision, and that's going to depend entirely on how force majeure is defined under the agreement. You have the change order provisions for compensable delays, and that's another issue that, again, drafting is so critical as far as what events give rise to compensable delay and what events give rise to the contractor's entitlement for a change order versus the owner, being able to shift that risk over to the contractor for delays of that nature. And then, of course, we already discussed it, but we had the price escalation clause that can be dealt with when there are major, when there are delays, there are commensurate price increases that result in needing to adjust the price for that reason.
And Amy, so Jack that just mentioned force majeure provisions as one of the kind of key issues that often comes into play in these types of agreements. But just kind of set the stage for us on force majeure provisions. What's a force majeure provision, and how can it potentially impact a price escalation claim?
So I think that force majeure was really the provision that most parties were trying to rely upon all through the pandemic before everybody saw this coming, right? We've seen tons of force majeure claims over the past 2 years because most contracts don't have price escalation clauses, right? I probably see that in maybe 10% or even less than that of agreements. It gets brought up quite a bit, but I actually don't see it that much. And so I think force majeure has been what I would consider to be the fallback provision for a lot of these problems that have been experienced with volatility in the market. And really, force majeure, well, first off, if you don't have that clause, you don't have those rights, right? I mean, I have a lot of people coming to me with, well, this is force majeure. I'm like, yeah, except for you, that provision is not in the contract, or it's not mutual, right? And so, it's important to note force majeure is entirely a creature of contract. It's going to mean what the provision says. But by and large, most force majeure provisions are really, they're allocating the risk of unforeseen events, and there's not a lot of thought put into what are all these force majeure events. And a lot of times after the fact, we are left kind of trying to deconstruct what do the parties think was unforeseen, or what was foreseen. There's a lot of arguments to be made on both sides that, price volatility and things like that are not force majeure. And a lot of it's going to depend upon what was the triggering event, right? A lot of parties making arguments that COVID was force majeure, and some parties make an argument that it wasn't. And then the further we get out from this, right, the further we get out from COVID or from the impacts of COVID, well, kind of starts to seem like you should have foreseen some of these things now, right? And so some of it depends upon, well, what was the situation at the time you entered into the contract? And so I think right now is a good time to take a look at everybody's force majeure provisions and really kind of have a good understanding of what they say, because at the end of the day, they're only going to allocate risk as to what the contract says, right? And, lawyers can be creative, they can make a lot of arguments, but, if you're going to use a force majeure for this, you need to put into a lot of thought as to, what risk is it allocating?
Yeah, absolutely. I totally agree with you, Amy. I mean, force majeure provisions are designed to allocate the risk for unforeseen events that no one expected to happen, right? And obviously, in March of 2020, COVID-19, the pandemic, the impacts that would happen after that was an unforeseen event, right? No one knew that was coming. No one knew what the impacts of that would be on ongoing projects. But it's not 2020 anymore, right? It's 2022. And so, at this point, when I'm on the owner's side and I'm negotiating one of these agreements, I really question whether or not COVID-19 or potential shutdowns or impacts on job sites, I question whether or not that is an unforeseen event anymore, right?
I exclude it specifically. So, be watching for that.
Right.
Both sides.
Yeah. And so, I think, so Amy, from an owner's perspective, you just said that you excluded specifically, but what are some of the ways that you can modify or draft a force majeure provision so that it mitigates an owner's risk on their projects with respect to these types of issues?
When I'm in the owner side of a force majeure clause, I like a tight provision. I'll be honest, I've never had an owner need to use the force majeure clause for a major construction delay. It's always been on the defensive side. And so I tend to like to draft those clauses to fairly narrowly capture force majeure events and not have just these broad, all these unforeseen conditions and things like that. Then we like to have, if you're on the owner side, you like to have a tight notice provision. The contractor has to provide notice, and to the extent the owner's providing notice at the beginning of the force majeure event after, let's say 10 days or something like that. So you want a tight notice provision so that the owner's able to adjust to the extent that a party's going to claim force majeure. And then what I typically see in force majeure provisions from the owner side is that there's no compensation for a force majeure event. There's only a time extension. And I think that's fairly well market, and I think that force majeure provisions really need to address whether or not there's cost or no cost, and many don't, right? And so I think that's the owner perspective on that. You want the tight notice, you want it the only extension of time, which no, that's not going to help for material escalation, right? It might help for material delays or delays in shipping overseas and things like that, but not going to be any relief on the cost side if a clause is drafted in that manner.
So Jack, give us the countervailing view on from a contractor's perspective. What should contractors be thinking about whenever they are reviewing, drafting, or negotiating a force majeure provision?
So my studied academic opinion on this is the opposite of everything Amy just said. I think that this comes back to a fundamental issue. If I'm the contractor, we use the term unforeseen a lot. If I'm the contractor, I don't like that term. I like the term events outside of the contractor's control. And that is how I would choose to try, if I'm the contractor aggressively negotiating a force majeure provision, I want compensation for all events that are outside of my control. Now, obviously, there are some limits on that are just frankly not realistic. And I think that we need to be careful with that, but we want to define the force majeure events as broadly as possible and not have this sort of bulleted or itemized list that Amy's talking about from the owner's perspective. We don't want a notice provision. We don't want a procedural requirement for notice. And also if there's some kind of extension that's warranted, we want that extension to be automatic, day-for-day extensions based on force majeure events without the need to demonstrate the delay to the project through critical path schedules or other onerous documentation. And so that's going to be what the contractor is really arguing for, that there's a broad list and that when there is a delay that it's automatically extended. And as for this provision on the limitation of remedies, obviously, as Amy said, I think that you get days, not money for delay is a market position right now in contracts, and I see it in almost every contract. I think that obviously contractors don't want that. There are limits under Texas law as to when that is enforceable, and so if the owner is out there intentionally interfering with the project, for instance, that's not really going to protect them. And so there are some protections built into the contractor for when there are delays that cause the contractor damage and increased cost, but obviously we don't want that as a baseline position.
Thanks, Jack. So, Amy, earlier you had mentioned that change order provisions and change order requirements are kind of one of the key ways that you can deal with these types of issues. So, Amy, from an owner's perspective, how can an owner use a change order provision in order to control or mitigate the risk of material delays or force majeure?
So, I really feel strongly from an owner's perspective that any increase to the contract price and any time extension should wrap back into your change order clause. So we shouldn't have, some provision somewhere in the agreement that doesn't roll back into the change order clause. The only way to increase the contract price, the only way to get a time extension, I recommend all of that be addressed in the change order clause. And that is the main tool for the owner to control the contract price, right? And so, from an owner's perspective on this, it's similar to force majeure. I want a specific list of things that can result in changes. I don't want there to be, questions about sort of these events beyond contractor control, right? I mean, that can mean weather, that can mean somebody else that the owner had nothing to do with, affected the cost or the delay on the project. That's way too broad from my perspective. Right, and so if price volatility is going to be reflected in a change order clause, and that's what the parties have agreed, then I highly recommend, from an owner's perspective, we have more specificity around that through a clause that's similar to this consensus clause, and that would be one of the enumerated reasons as to how you could get a change under a change order clause. Also, we're going to have some form of notice, right? The worst thing, really, I think, from an owner's perspective, is to get to the end of the project and, oh, surprise, there was a change order 2 years ago, And so we want to have those tight notice provisions to try to be able to argue, well, we could have done a number of things had we seen these changes coming, had we known there was going to be a delay, had we known there was going to be all these price increases. We could have supplemented, we could have done all these things. And so that's extremely important from the owner's perspective. And then there's a lot of other things that you can do once a change order is signed to make sure that that was the final deal, right? Accord and satisfaction language is common, waiver of delays through a certain change order. And so, there's a number of things that can be done with the change order clause to both manage price increases and delay generally. And of course, a lot of things that we're really not talking about today, but those are the key subjects for today.
Okay, and so when it comes to delays, I think one of the things that you commonly will see is a no damages for delay clause, right? So the idea that if you are delayed, you can get and the contractor submits a change order request, you can get an extension of time, but you're not entitled to any costs that are associated with the change order related to the delay. And so these no damages for delay clauses, Amy, are those enforceable under Texas law?
They are enforceable, but we have to keep in mind the key exceptions to no damages for delay, which were, I suppose, reaffirmed in the Zachary case at the Texas Supreme Court not too long ago. And so there's a couple of different ways that even if you have a no damages for delay, that the court's going to find that type of provision is not enforceable. And just to kind of back up for a minute, what we're talking about with a no damages for delay is that even if the contractor is delayed by the owner, by events on the project, that maybe they get time, but they're not going to get any damages. That's what we're talking about with a no damages for delay. And so the courts have said there's some limitations on that. So even if that's in your contract, for example, if there's owner interference, fraud, or some other exceptions, that's not going to be enforceable. Okay, and really on larger, more sophisticated projects, I don't see no damages for delay as frequently as perhaps on some commercial projects and things like that are smaller. I think that probably the more middle position, probably the more measured position, and also just kind of in the spirit of we're working together to try to get the project finished timely. I see a lot more contract clauses that are drafted to just control delay. So I see compensation for delay in a lot of contracts, but there's various hoops that are typically rolled into change order clauses to account for delay that makes a contractor demonstrate to the owner that the cause was actually the cause of the delay, right? So we need to have a critical path analysis, we need to have timely notice. Otherwise, that Jack kind of alluded to this concept of a day-for-day delay, if there's two events that are concurrent with one another, one caused by the contractor and one caused by the owner, should the contractor get the day-for-day extension? They were already behind, right? So the idea of making a contractor demonstrate a critical path delay through, say, a material delay or something like that, I think that's really fair for both sides to determine whether or not it's really a compensable event.
And I think there are two other types of situations in which under Zachary a no damages for delay clause might not be enforceable that I've seen people argue to limited success. The first one is if the source of the delay for the damage was not contemplated by the parties at the time of contract signing. And the other one is if the length of the delay was so long as to not have been contemplated. And really, under the case law, it's when the delay is so long that the contractor would be justified in abandoning the work. And so when you're talking about, things related to, COVID-19, for instance, is a good example. You get back and you're kind of going in this circle where you say, well, we had this unforeseen event, and the owner says, fine, but you don't get any money for that. And the owner the contractor then says, well, right, but I get money for that because this isn't enforceable because I didn't foresee it. And then you just go in this big circle. And I think, I don't think that those provisions those exceptions are as broad as some people asserting those positions like to think they are. So don't assume if you're signing a no damages for delay clause as a contractor that you're going to be protected by something like this, by the Zachary case. I think you need to be careful and understand that you're probably going to get the bargain that you're striking with the owner, and as you put in writing.
And so, Jack, just to kind of follow up on that, when a contractor is looking at a delay provision or a change order provision, what are some of the strategies with respect to delays that a contractor should keep in mind to make sure that, or to enhance their ability to make sure that delays that are outside of their control are actually compensable under the contract?
They're really not that different than the general force majeure concepts that I talked about earlier when I took exception to some of the things that Amy may be pushing for from the owner perspective. And I am again very glad that she's on my team and that I'm not having to go across the table from her on this. But you want to broadly define what gives you the right to a change order and seek that relief. And I think that Amy talked about accord and satisfaction clauses and kind of protecting the owner by making it clear that when you sign a change order, you're giving up rights to future compensation related to that change or related to things that happened before that date. I think that one thing that often happens, and I see when these cases go to litigation, is that the contractor will bring a claim and say, well, yeah, I signed that change order back 2 years ago, but I had no idea at the time that it was going to have such a giant knock-on effect on my productivity, or that it was going to cause other delays, or that it was going to be part of a rolling, cascade of mistakes or problems that were encountered on the project that would entitle me to an impact claim of some kind. And so the contractor wants to try to have some language that preserves their right to bring that, and to supplement their notice if they become aware of something that's going to drastically modify the nature of their request for relief. And the key way to do that is to try to avoid the accord and satisfaction clauses, the full and final payment clauses that Amy's talking about that would be either in a contract. I've seen it where it says there's an actual contractual provision that says every change order you execute constitutes accord and satisfaction and full and final payment. Or you'll see it in the change order itself, that this is full and final payment for everything associated with this change. If I'm the contractor, I want both of those things out of there and as far away from my project as possible. But I do think that the realistic expectation is that there is going to be a market position where the contractor is limited in some way and can't just bring those claims in perpetuity. But that's what I would look for to try to protect my client as a contractor.
Let me add one other thing that I thought of. So, both owners and contractors really need to be careful on how these change order forms are getting filled out. So when we get to the end of the project and, there's a massive delay claim, maybe it's because there was a key, piece of equipment that got significantly delayed in the market we're dealing with right now. As you go along and you're executing change orders, both as an owner and a contractor, you can't just pay attention to contract price, right? There's almost always a slot or a place to fill out how the change affected the contract time. And, if the contractor or the owner are not paying attention to those, boy, you're going to start to understand how they affect your case in a delay. That's the very first thing that any claims consultant looks at is, okay, well, how did this project get extended over time on the change order form? Was that the contractor filling in the same date of completion the whole time? Because if they were, the argument is, well, you weren't delayed, right? Because you told us over and over and over again with every change order you signed on this project that there wasn't a delay, okay? And so, and by the same token, on the owner side of this, if that's not getting filled out, you're not using your change order form to its fullest extent, right? Or if you're not paying any attention to what that date is and you're signing this over and over again, then, you might have admitted there was a delay on the project. And so think about that change order form. And in your contracts, when we're dealing with such a volatile market, I really recommend your change order form is very well thought out, contemplates all these contract price adjustments that we're talking about. It shouldn't just be for lump sum. It should actually contemplate the adjustments to the contract price. And how are we going to show schedule changes with each change order? The guaranteed substantial completion date has now changed to this date, right? And maybe you want a schedule attached. Maybe with every change order, you want a schedule attached to understand the changes to the project. So, a lot of tools in the toolbox for both parties really to understand, how each change along the way is affecting the course of the project.
And on the issue of making sure it's filled out correctly, Amy talked about having the completion date never change. I've also seen a case that where the date was filled in as TBD, which is a really great way to raise your blood pressure as a client and to pay your lawyers a lot of money. So don't do that.
I think another one of the key issues that always comes up in connection with the change order claim are the notice requirements and the deadlines that are associated with your requirement to give notice of a change. And just kind of from a general Texas law perspective, Jack, are those notice provisions going to be enforceable?
Typically, yes. I think that courts try to have over the years tried to avoid requiring strict compliance with every single part of a notice provision, and there's a lot of case law on that. Up until recently, even oral notice or actual notice could sometimes be sufficient when written notice is contractually required. Now, the Texas Supreme Court in 2021 with the James Construction Westlake case has now held that if there's a written notice provision, there is at least some written notice required, that the contract means what it says. The court didn't go far enough to say that every single stricture of a notice provision has to be enforced, but if the contract requires written notice, you have to give written notice of some kind. And how that continues to be refined by case law remains to be seen, but it's clearly trending in a direction to where if you're going to contract for a form of notice, that you need to provide that form.
And I think another thing that people need to keep in mind is that often there's a specific timing restriction, right? That the notice has to be given within 7 days, and notice has to be given within 14 days. And for a long time, it was somewhat ambiguous as to whether or not those strict time requirements were actually enforceable, right? Could you argue that if the contract requires 7 days notice and you give 10 days notice, is that a failure of a condition precedent that would mean that you can't actually get that change order, right? And so for a long time, kind of one of our go-tos, if we were trying to argue that one of those strict timing requirements was ineffective, one of our go-tos was a provision in the Texas Civil Practice and Remedies Code that says that a provision that requires notice of a claim for damages within fewer than 90 days was void, right? And so kind of one of our standard practices, if we were arguing one of these claims, was to say, well, no, look, that notice provision is shorter than 90 days. And so under Texas law, that's an invalid notice provision. And so, if even though the contract required 7 days notice, I gave you 21, 30, whatever it was, that notice was sufficient under the contract. But recently, there's been several different cases across the state of Texas that has really looked at change order notice provisions in detail and has parsed the language in order to determine whether or not that provision in the Texas Civil Practice and Remedies Code actually applies to those notice provisions. And what the court has focused on is the language in the statute that says notice of a claim for damages. And so what the case law has looked at is what is notice of a claim for damages, right? So if I have a provision in my contract that says I have to give notice of a change within 7 days of the change occurring, and then 14 days later, I have to give notice of the amount of the change. And then 21 days later, I have to give notice of my submission of a change order. Are all of those different notice provisions, or all of those notice of a claim for damages? And what the court has said is that no, they aren't. So a provision that says you have to give notice of a change order event within 7 days or within a certain amount of time of that event happening, what the courts have said is that that's not actually notice of a claim for damages. Instead, it's notice of a claim for potential damages, right? Because a change order, a change claim or a claim for damages that arises from a change event doesn't actually become a claim for damages until the owner says, no, I'm not going to give you that change order, right? Because if the contractor gives the owner notice of a claim, and then the owner says, okay, here's your change order, Well, I don't have any damages, right? Because we've all done what we're supposed to do under the contract. You don't actually have a claim for damages until the owner says, no, I'm not going to give you that change order that they should have. And so I tell you that to make sure that everyone is aware that, for a long time, this was kind of gray, right? And as lawyers on the litigation side, we love gray areas under the law, right? Because that's where we live. That gives us a chance to operate. That gives us a chance to argue on different sides of a provision. And the enforceability of these notice requirements is getting less and less gray. It's becoming more black and white. And so if you have a notice requirement that has a strict timing deadline in it, you need to do your best to, as a contractor, to comply with those provisions. Now, so kind of moving away from change order provisions, there's several other provisions that could potentially impact a price escalation claim. And so another one that we haven't talked about yet is a waiver of consequential damages. So Amy, how can a waiver of consequential damages potentially impact a price escalation claim?
And so, and I'm thinking more of volatility and materials in general, because a lot of times with consequential damages, what you're worried about are delay claims, right? If we have a massive delay due to all these supply chain disruptions, has our consequential damages clause really accounted for all the things that could potentially go wrong there? I see a lot of parties agreeing to consequential damage waivers and not necessarily thinking about all these implications, right? There is no categorical agreement on what is consequential and what is not. The Texas Supreme Court has actually come out and said there's no bright line. We're just going to tell you right now there's no bright line. And so you get arguments on both sides in a lot of instances. And so you have to think about a scenario where there's been a supply chain disruption, there's a massive delay. Okay, what are the damages associated with that? A lot of times from the owner's perspective, you're talking about damages or lost profits pertaining to other contracts, okay? So, the hotel didn't get open timely because we couldn't get any of the doors because they got stuck in the supply chain, right? And then a lot of the owner damages to that tend to be these delay costs for not being open on time. If you have a consequential damage waiver, then there's a pretty darn good argument that those damages got waived, right? And so, in the volatile market, I think it is appropriate to spend a lot more time negotiating that consequential damage waiver. The other thing I tell a lot of clients to think about is, if you think a lot of your damages for delay might be consequential, what about a liquidated damages provision, right? To where, we're taking it out of the realm of consequential damages and we're deciding up front what those delay costs are to the extent that the owner is going to have delay costs for contractor delays. And so in a volatile market in particular, I think that becomes even more important to put more thought into your consequential damage waivers.
Yeah, and I think that's especially important when you consider just what is the difference between direct damages and consequential damages and how that difference is defined, right? Because a lot of people have heard the language direct damages, consequential damages, and everyone, like Amy said, thinks that there is a bright line, but the way that the distinction between those two types of damages is made is in the definition, and it's really confusing, right? So direct damages are those damages that flow naturally and necessarily from the breach of the contract. Okay, naturally and necessarily. Okay, that seems to make sense.
It doesn't, just FYI. Not according to the courts. But.
So then consequential damages, right? Consequential damages are those damages that flow naturally, but not necessarily from the breach. What does that mean, right? So what is something that flows naturally from a breach, but not necessarily? And so, I think it's important for everyone to understand that, the courts struggle with what is a direct damages in a particular case versus what is a consequential damage. Often it's fact specific in each individual case. You're going to be looking at what the parties were discussing up front. You're going to be looking at the actual terms of the contract. You're going to be looking at what was the goals of the contract. And so, these waivers of consequential damages, people have to pay a lot of attention to how they're being drafted, because it's one of those areas where you can have a lot of unintended consequences that come from either the way that it's drafted or the lack of one, or the lack of detail that is included. And talking about detail, Amy, how do you feel about just kind of boilerplate general consequential damages waivers versus something that has a little bit more specificity?
I can tell you right now, I put a lot of thought into the ones I draft, so I don't recommend that. I negotiate carve-outs, and when we talk about a carve-out, essentially what we're saying is, well, we might have this waiver of consequential damages, but the following things are specifically not consequential damages. And if it's covered by insurance, or some of these other things we see, or there's gross negligence and things like that, which almost never happens, but maybe sometimes you got to argue that. Those types of things are going to be exempted from the consequential damage waiver, right? And because kind of knowing in many instances, especially from the owner's perspective, some of your damages really might be consequential. So let's make sure some of the things that we thought were damages are not. And also, if there is a remedy out there, even if somebody thought it was consequential, we're still, that remedy that we thought was available is still available.
And Jack, so kind of moving away from waivers of consequential damages, are there other limitation of liability type provisions that can be included in a contract that can impact, or that can be used to deal with price escalation issues?
Yeah, I think that the overall limitation of liability is really exactly what it sounds like, and it limits when there's a compensable event that gives rise to liability from either perspective, there's going to be a limitation on the maximum amount that can be assessed. It's either going to be a whole dollar amount, or sometimes is used as a multiple of a contract price, just to try to make sure the parties all know what they're signing up for in terms of what their maximum liability is going to be. Now, they're almost always enforceable to the fullest extent under Texas law, unless they somehow run afoul of public policy, which is just a really, really high bar to clear. Or if you're supplying goods under the UCC, if the remedy that you're seeking, fails its essential purpose, there's an argument to be made there that it doesn't apply. But it can be used with materials, because just like material costs and increased costs are going to provide liability between the owner or the contractor, and so it can, those increases are likely going to apply to the limitation of liability clause. And so if you have one in your contract, I think it's really important from either perspective to understand that even if you have price escalation clauses, force majeure provisions, change orders, all of those things we've talked about, a lot of times they're going to just end up going right back in and flowing into the limitation of liability and having an overall cap that still has you out there with a lot of risk on the table. And so I think that, just like the consequential damages waiver Amy talked about, there are a lot of times there are exclusions such as gross negligence, there's indemnity, there's insurance proceeds that get excluded from these provisions, but be on the lookout for them and understand that they also will impact your remedies and rights, even if you have all these other protections available to you.
Great, thanks, Jack, and thanks both to Jack and Amy. I really appreciate the discussion. Does anybody have any questions or comments that have come up in connection with any of the things that we've discussed this morning? Yes, sir.
I'm just going to repeat the question so that just to make sure everybody heard. So the question is, how are we accounting for volatility in labor and labor shortages, which has plagued the industry over the past few years? And I will say I don't see clauses addressing labor shortages very often at all. That is generally a risk thought to be borne by the contractor. And in fact, I think it's excluded from a lot of force majeure clauses. In particular, if what we're talking about is, labor that is the contractor labor. From time to time, I will see that if there's a strike or something like that, let's take like the railroad strike that recently came up in the news. That's not really the contractor's forces, that's other forces. So that issue might have resulted in a force majeure, and I've seen a lot of clauses deal with that. But I think the labor problem is very complicated. Would be very difficult to deal with through a price escalation clause. And to the extent that the market has become so volatile with respect to labor, then what you're probably more likely looking at are, T&M type contracts or cost-based contracts. If I'm on the other side of that, from the contractor on the owner side, I'm going to want some type of cap on costs associated with labor volatility. But a very complex problem that probably is not dealt with very, very well at all in most construction contracts.
And, if you are thinking about drafting, some sort of a clause that's going to deal with volatility in the labor market, there are indices that you can go to that track, the different changes in general labor rates, right? And so, if you are drafting one of those provisions, you may think about referencing one of those indices, like one of the ENR indices that tracks, kind of general changes in labor, in various major metropolitans across the U.S. You may tie, the change in an overall change in the market based on, either some of the key markets the ENR tracks or, the entire nationwide indice. But if you were drafting one of those types of provisions, you're gonna have all of the same issues that you have with the material price. You just have to adapt it to make sure that you are tracking it in a fair way that makes sense for everyone.
Yeah.
But I think there was another hand over here, Jim.
Yeah. So the biggest thing that we see from the contractor side is the owner not understanding what happens if they delay the start. And so, whether they've got, maybe it's a government entity that has to get some sort of bureaucratic approval to start, or it's a private entity that's got to get their financing in place and get their investors on board, whatever. They tend to be lax in the timing of how that plays out, but they want the contractor to hold their bid. The contractor has bid. So they've given them a bid that they can take to get all their other stuff in place, and they expect that bid's going to hold. But then they'll carry that out 6 months, and it used to be that 6 months might not be a big deal, but 6 months is a big deal now. And so, from a contractor's perspective, we don't want the project to start off on a bad foot where we're already having to hit the owner up for more money before we even get on the job. And so I don't know if you guys have had any experience negotiating that interplay between the contractor and the owner. The other thing that happens is, if you push it 6 months, pouring concrete in July is different than pouring concrete in December. It's not the same project if you do that. So I don't know if you guys have had any success, working that out between a contractor and an owner or not.
That issue arises routinely, right? So the question is, what happens if the owner delays the start of the project, and in the interim, things have changed, prices have gone up, we're in a different season. So I see that issue play out a number of ways, right? So sometimes nobody deals with it at all, and there's not even a start date in the contract, right? That is probably the worst case scenario for the contractor. If I'm on the contractor side of that and I'm trying to set up for a change having accrued, I'm going to do a couple things. Obviously, your proposal is going to be limited to a certain period of time, right? With that proposal, you're going to have the start date identified on your very well thought out schedule, right? And then when it goes time to sign the contract, if there's been the delay there, if the schedule's already been delayed and you already have a delay in the schedule, you got to account for that in the contract. Don't ignore it. Don't think it's going to work out. It may not work out. It might work out. You might get lucky, but I if there's a delay between bid time and contract time, deal with it at the time of signing when everybody's probably getting along a little bit better, right? Because owners don't like to get changes at the end either. And so, you want to go in the contract, you want everybody to get along, and I think that the best way to do that is to be upfront, to have the discussion at the time of contract signing.
Yeah, one of the most frustrating things to see from a litigation perspective when you enter into disputes that arise from issues like this is when you're looking at a contract that was signed in August that incorporates a schedule that was part of the proposal into the contract where the start date was April 1st. And then the contractor starts work in mid-August. I mean, at that point, it's very difficult to flange up, okay, well, why didn't you account for that? And even in situations when the contractor then says, well, I was delayed from the beginning, so I should get equitable schedule relief, or I should get schedule relief through the contract, there's an argument to be made of, well, you incorporated that into the agreement that you signed, so what is your problem? And I don't know if I've seen anyone get totally poured out on that basis, but it's all about increased risk, increased litigation costs, and what you're going to be fighting over.
And if I'm on the contractor side, I'm putting the contractor hat for a moment. And nobody wants to account for the delay. I want my original schedule there to show when I had planned on finishing to start with, right? And so I think, you're going to either get along and talk about it, or you're going to insist that the contract be the way that you understand it to be from the outset.
Any other questions or comments? Yes, sir.
Almost all of our contracts deal with governmental entities who still, at this point, think that price increases and getting stuff to a job site are a myth. Two years into this mess. Do you have any strategies to nudge some of these governmental entities and some of these people into modifying their contracts? Because you're talking about contracts that you can modify beforehand. We go into bid documents that have been set up 40 years ago. Nobody wants to make any changes. And it's difficult to do much of anything.
Yeah, the question, I think, is about when you're bidding government work, you have a different challenge because the governmental entity has the contract documents set out a long time in advance. And so what to do when governmental entities won't budge on the fact of price increases and schedule relief that's necessary, when you're at the time of contract signing. And my answer to that question is governmental entity. It depends in part on the project delivery method that is being used, whether the challenge is going to be that on a governmental project, when you're doing something that's purely, lowest valuable, lowest responsible bidder, there are always going to be entities out there that are contractors who are out there willing to take on all of that risk you just talked about. And so governmental entities, I think, are going to be less incentivized, at least on the front end, to try to make those changes and make the bid more palatable to bidders that might be more expensive, but might also, in the long run, be more responsible and be able to get the job done in a more efficient way. I think that I don't have an answer for you on how to convince them really to accept those changes. I think that over time, those are going to start becoming more obvious, that there are going to be, that contractors who come in and say, oh, I can do this on this really fast, rapid schedule or for a really low bid, those always wash out, and governmental entities learn from those experiences. But as far as individual, negotiating tactics to try to get them to change their contract documents, for instance, sometimes that comes with the territory of working for a government.
Yeah, I'd say, practically speaking, probably the only thing to do is build in risk. I mean, that's probably the only practical way to deal with those types of contracts. Building in the risk and the pricing.
Yeah, and you can also get creative with the way that you either with the way that you structure the pricing. You can deal with it through contingencies. You can deal with it through allowances, and then building in a change order requirement that allows different use of either the contingency or an allowance or something along those lines, so that you've got a little bit more flexibility. But again, like Jack said, I mean, it just kind of comes with the territory, right? With a lot of those government contracts.
I mean, I've seen times where contractors have float built in their schedule, of course, because all of them do, at least the good ones do. And there's a big delay in getting the project started, and the owner says, well, that's fine, because your float, well, we have float, so we just consumed all your float. And, you know, yeah, it's not an easy situation to be in.
Well, got a couple more comments.
Yeah, I have a comment. The one thing with the project delay that you talked about earlier is that then the contractors that we have, and we have the products that we're purchasing and the equipment, we need to extend the warranty. Now, it's come back that the owner says, no, those extended warranties are your responsibility. They're not ours. We're not going to pay for that extended warranty, even though it's under our prime contract. We're responsible for the warranty through, whatever period, it doesn't matter, after substantial completion, then the warranty period starts. Well, then we need all of our contractors and the suppliers to have their warranty for their products to extend through that. But in one circumstance, they said, no, those are your costs, and they can't be our costs. So how do you respond to something like that?
And so, just to repeat the question, how do you account for a contractor's project delay, or maybe it's an owner, but I believe the scenario is a contractor project delay, and then we don't have extensions of the downstream parties like the subcontractors and the suppliers under the contractor. So in order for the contractor to make the argument that you're talking about successfully, they have to have carved out of their own warranty responsibilities supplier and subcontractor warranties. And I do see that provision frequently. I do see a provision where, they say that, essentially whatever the supplier's warranty is, that warranty is the extent of our obligations. And, I often tell owners, you have no idea what the warranty terms are with this downstream party. You haven't negotiated them. You haven't seen the contracts. If you want a true prime contract, then you've got to have the same warranty. And and under that scenario, it's not the owner's issue, it's the contractor's issue, right? If the contractor has negotiated the provision I'm talking about, then yes, it could be your issue. You might have to buy extensions because you only get whatever warranty that this supplier is offering. So you have to have basically a multi-tiered warranty provision in order to have the contractor successfully make the argument you're describing.
I think there was one other comment over here.
We were having a discussion here about, from the subcontractor standpoint, material escalation. How do these provisions apply to a subcontractor or a supplier?
Okay, so the question is, we've been talking a lot about the scenario of an owner in a prime contract. How does a subcontractor get additional cost increases if they're under the prime contract? And a lot of this will end up coming down to whether or not the subcontractor is under an umbrella under the prime contract, where the prime contractor gets relief for material escalation. Right? Because in a lot of our subcontracts, we have pay if paid clauses or pay when paid clauses that make essentially the prime contractor has to be able to get a change order out of the owner in order for that money to flow downstream. Now, that's the typical scenario. It doesn't have to be that way. The subcontractor can negotiate the same types of price escalation clauses in the subcontract agreement as in the prime contract agreement. Those agreements don't have to match up. Everyone tries to make them match up, but if the sub needs flexibility in a certain area, then it's incumbent upon the sub to ask for those protections in the subcontract as well.
And I think from a subcontractor perspective, right, one of the things that a subcontractor is typically going to be dealing with is a flow down provision, right, that says, you, Mr. Subcontractor, owe me, the contractor, all of the same duties and obligations that I owe to the owner, right? So it's perfectly reasonable for a sub. If you have a prime contractor who's going to flow down those provisions, the sub should always say, okay, well, if you're going to flow those provisions down to me, one, I need to see what the prime contract says. I mean, I can't tell you how many times I've talked to a subcontractor that is doing work under a subcontract that has a flow down provision in it, but they've never seen the prime contract, right? And so if you're a sub who's going to be doing work under a prime contractor, and your subcontract has a flow down provision, ask for the prime contract so you can see, right? And if you have a chance to look at it, if you do that and you look at it and you see that there's a price escalation clause that the contractor and the owner have agreed to, or if you've got some other provision in that contract that is designed to deal with changes in material prices, you should ask to have that same provision included in your contract, right? You should be trying to mirror the duties and obligations and the benefits also that the contractor has with the owner in your subcontract. And then build off of those provisions so that you make sure that you can send that claim back up to the contractor and give it to the owner, right? And you know, another thing that I'll occasionally do for a subcontractor, if there's a flow down provision along those lines, I'll say that, okay, if you're going to flow everything down to me, well, then I'm going to say, okay, and you, Mr. General Contractor, you owe me all the same duties and responsibilities that the owner owes to you, right? So a flow up provision so that it goes both ways. And so that way, if there is a mechanism that's included in the prime contract for dealing with changes in pricing or price escalation issues or material shortages, I know that me as the subcontractor, I get the same benefit of the provision that's included in the prime contract. Anybody else? Okay, well, listen, thank you all so much for being here this morning. We really appreciate it. You know, like I said at the start, it's really great to have everyone back together in person. You know, I'm so happy to see everyone here and get to shake your hands and see people, you know, face to face. So thank you so much for coming out this morning. We really appreciate it. And so one of the things that we did this morning is we recorded this session. So if you've got colleagues or anyone else that you know that wasn't able to attend this morning, have them get in touch with us because we'll be able to send them a version of this presentation that they can watch or stream or, you know, watch on their own time. So, you know, just have people reach out to us if they want more information or they'd like to get a copy of the or if they'd like to receive a video of the presentation. So thank you so much. Appreciate it.